Hello, welcome. Today we're going to be learning about the judicial system. And I know you're saying, we just took a test on that included the judicial branch. Why do we need to learn more? Because the judicial system is actually quite complex. We're going to talk about some types of cases today. We're going to talk about jurisdiction. We're going to talk about federal courts and state courts. A little bit more about due process, right? All these things you're going to need to know. You've each been given a packet. The first couple of pages are vocabulary, so this video won't be too helpful with that. Although this video will accompany the rest of the information in the packet. Alright, so let's just jump right into it. Today we would like to determine how criminal and civil cases are similar and different, right? Likenesses and differences. So on page 4 of your packet, you'll notice an activity that we're going to be working on throughout the unit. In this, you're going to have to choose 2 clients, one from each box, and pick their names. We're going to be preparing for a client interview. You're going to interview these people, and you want to be able to make sure you're giving them the proper information. After you've finished that, answer the question on the bottom of page 4 of your packet. And if we have time at the very end of class, you could go on and keep reading. For now, just make sure you read far enough to answer the questions and the box below. Alright, so if you flip over to page number 5, you'll need to know the basics of a civil case. There are 2 sides. There's a plaintiff and there's a defendant. The plaintiff is the person who is accusing the other of wrongdoing, right? They're the accuser. These types of lawsuits can involve disagreements about something. So it could be about where property lines are. It could be about whether or not a contract was legal in the first place, or if it was carried out correctly. It could be about divorce or custody proceedings, personal injury and or negligence, right? All these things could be a civil case. The court's job is to decide what party is liable or responsible for the event that occurred. At the end of the case, the court will award compensation or damages to the winning party. So the procedure, it goes as follows. Go ahead and write in these words in the boxes on page 5. So the plaintiff files a complaint with the clerk of the circuit court to recover damages or receive compensation. The plaintiff, the accuser, says, I need this person or this business to pay me for the wrong they have done. And then, after a period of discovery, that is a period in which both sides gather evidence to make sure they have all the information regarding the event that is being brought up. After the period of discovery, a trial will be held either before a judge or a jury, and either the judge or the jury issues a ruling on who is liable and how much damages should be awarded, if any. Which means that depending on the type of case, depending on what's going on with the case, it might be presided over by a judge or a judge and a jury. If either party, the winning party or the losing party, doesn't like the decision, I don't know why the winning party would appeal. They probably won't. I take that back. If the losing party doesn't like the decision, it could be the plaintiff or it could be the defendant. If either party doesn't like the decision, they can appeal it to a higher, different court, which we'll learn about a bit later. Alright, so now below you will find a link to Criminal Law Basics and answer the questions on the bottom of page 4 below. You could go ahead and scan the QR code, click the link, and you should be good to go to get there. Again, pause the video, make sure you're able to do that first before we move on. All right, so in a criminal case, the defendant is accused of breaking the law by committing either a felony or a misdemeanor. There are two different types of crimes. We're going to get into the differences here in a bit. In a criminal case, a court determines whether a person is accused of breaking the law, whether the accused, they determine whether or not they're guilty or not guilty. And the defendant, the person who's being accused, could be sentenced to jail time or maybe a lesser sentence. They could be issued a fine, right? They would have to pay money. They could be forced to do community service. There are any number of things that could happen. If you're found guilty of a crime, you might not always go to jail. You might have a lesser sentence depending on the severity of the crime. So here is the procedure for a criminal case. So a person accused of a crime could be arrested if the police have probable cause, right? The idea that you are more likely than not have been the one to commit this crime. The case proceeds to an arraignment where probable cause is reviewed. An attorney may be appointed for the defendant if the defendant cannot provide one for themselves. An attorney may be given to them, and a plea is entered. So at the arraignment, a plea is entered. You could plead not guilty, you could plead guilty, or you could plead no contest. After the arraignment, the accused may be committed to jail, right? They may be in jail, or they may be released on bail, right? So if someone says, I need you to bail me out of jail, that means they have to pay money to get out of jail before their court date. When a court date is set and a court date is set and a trial is conducted, and lastly, a verdict would be rendered, right? A verdict is the decision. Are they guilty or are they not guilty? And a guilty verdict can be appealed. Alright, so now you're going to need to start preparing for your interviews. Because you're going to need to be able to give your client advice. You're going to be a lawyer, you need to be able to give them advice. So be sure to answer these questions located on page 13 and 14 of your packet because they will help you later on. So, is the case that you have chosen, or are the cases, are they civil or criminal? And how do you know, right? So is there a law being broken, or is there a injustice being done to somebody? Skip over the jurisdiction question. We're going to learn that next, and we're going to identify what procedure the specific case will follow. Alright, so now we're going to learn about the federal court system. Federal courts, state courts, how are they organized? What jurisdiction do they have? Go ahead and read the following article. It's listed below on your packet, and it's also up here on a QR code. You're going to be able to need to answer the questions about the structure and function of the courts. Alright, so the federal court system, right? There are three main levels of it, and it's set up in Article 3 of the Constitution, right? Which you already knew. You knew already that Article 3 talked about the judicial branch. Article 3, Section 1 says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Alright? So they say you need to have a Supreme Court, and then there are other courts that Congress may want to make. So what we ended up making is the United States Supreme Court, right? That's the highest court. And then they made the U.S. District Court. And the U.S. Court of Appeals. The U.S. District Court is usually the first court that would hear a federal court case. It's usually the first court that would hear a federal court case. Let's say someone is found guilty. Then it could go to the United States Court of Appeals. It could go to that second tier of court. And then let's say they're found guilty again. They could then bring this up to the United States Supreme Court, depending on the specifics of the case. You'll notice off to the right-hand side, it says original jurisdiction next to United States District Court. That means that they are the first, or they have the ability to hear the case for the first time. They have the ability to hear the case for the first time. The U.S. Court of Appeals has appellate jurisdiction. That means that they can hear appeals. They cannot hear a case for the first time. They only can hear after it's been appealed. Now, the United States Supreme Court has both. The way I like to remember that they have both is that they are supreme and what they say goes. But they have both in a kind of different way. They have appellate jurisdiction, so already talked about that. You could appeal to the Supreme Court after you go through the other two. But they also have limited original jurisdiction. So depending on what is happening in the case or who is being a part of this case, the United States Supreme Court may be the first. So I kind of said all this on the last slide. In original jurisdiction, the court has the right to hear the case first. And original jurisdiction cases, the general, hold on. Yeah, the United States District Courts, right here. These ones oftentimes have both judges and juries. An appellate jurisdiction means that the court hears an appeal from a court of an original jurisdiction. So they'll hear an appeal from someone who has original jurisdiction. All right. The federal district courts serve as trial courts. So that means they include judges and juries. The circuit courts are appellate. They're appellate courts. And in the appellate court, there's no jury. I'm going to say it again because I don't feel like I said it well the first time. A federal district court or trial court has original jurisdiction, right? This is when there will be a judge and a jury. The federal circuit courts serve only as appellate courts, so there would not be a jury. The United States Supreme Court serves in this manner only as an appellate court, right? So there's no jury that gets to hear a case that goes to the Supreme Court. Alright, so that kind of lays out how it works in the federal court system. However, it's different for every state. Now, because we live in Virginia, we need to know about Virginia. And just like the United States has a constitution, the state of Virginia has a constitution. And just like the judicial branch is set up in the Constitution of the United States, and the Virginia Constitution, they set up the judicial branch. It says, the judicial power of the Commonwealth shall be vested in a Supreme Court, and in such courts of original or appellate jurisdiction subordinate, that means underneath, to the Supreme Court as the General Assembly, or lawmaking body, may from time to time establish. Trial courts of general jurisdiction, appellate courts, and such other courts, all shall be so designated by the General Assembly, shall be known as courts of record. Alright, cool. So, here we have the order or so that things can go through in the Virginia court system. First, you have the magistrate who decides if it goes to the district court, where there's juvenile and domestic relations, right? They handle juvenile and domestic relations. Um, so juvenile is people under the age of 18, and domestic relations, family matters, right? This would be heard only by a judge. There are general district courts, right? These are other courts that they may be given to. They have original jurisdiction, and they also only have a judge. A circuit court is for when there's a felony or high value civil cases. So a felony, it's a more serious crime than a misdemeanor. Um, and this also can serve as an appellate court from the district courts. So the Virginia Circuit Court has both original jurisdiction and appellate jurisdiction, depending on what um, is going on. So if there's a felony, it goes straight to the Circuit Court of Virginia, or if the monetary value is significantly high, then it will go to the Circuit Court in a civil case. If it's a civil case, the General District Court can hear it, unless it deals with family matters. Then we'll go over here. Now let's say we had a court case that dealt with family matters and it wanted to be appealed. It could go to the circuit court. After the circuit court, though, there's the Court of Appeals. The Virginia Court of Appeals only has appellate jurisdiction, meaning they can never hear a case for the first time. However, you could bypass the Court of Appeals if you commit a crime that is so bad that you're going to be given the death penalty. This is an electric chair. If the crime you commit is so bad you're going to be given the death penalty, you could skip the Court of Appeals and go straight to the Supreme Court of Virginia. They too have appellate jurisdiction. All right. So here we have kind of the same information laid out a little bit differently. In Virginia district courts, they have original jurisdiction for misdemeanors. They're more minor crimes and small civil cases. They also have original jurisdiction in juvenile and family matters, right? And that would only be heard by a judge. The Virginia court hears crimes for felonies. They have original jurisdiction for felony cases, and in rare instances, right, civil cases when the dollar values go up. There's a judge and a jury, and they have appellate jurisdiction from district courts. One step above that, you have the Virginia Court of Appeals. They only have appellate jurisdiction, right? They reviewed the decisions from the circuit courts. And lastly, you have the Virginia Supreme Court that has appellate jurisdiction and limited original jurisdiction. Alright, so at this time, you need to continue preparing for the interview session that you're going to have with your clients. Review the types of cases that are heard and answer these questions that are on your worksheet. So will their case, I believe this should also be on page 13 and 14. I'm double checking that now. Yes, I believe it is. Alright, so will their case be heard in a state court or a federal court? Why? What kind of crime are they committing? That will probably help you out. What jurisdiction does their court have? And will their case be heard by a judge or a judge and a jury? Alright, now we're going to move on to judicial review. We've covered judicial review a little bit before, but it's worth repeating. So judicial review is a power given to the Supreme Courts in the United States and Virginia to determine the constitutionality of laws passed by the legislative branch and the executive branch of government. Now, this came from the Supreme Court Marbury versus Madison, um, in which there's a man, his last name is Marbury. He believed he should be a Supreme Court justice, and things didn't quite go well for him, so um, he sues, and it turns out the Supreme Court rules that the way the events unfolded, it was unconstitutional, which first established judicial review. I'm going to have you do a short reading about judicial review, but it's worth noting that state laws must conform to United States and Virginia Constitution. State laws must follow the United States Constitution and the Virginia Constitution. One of your clients is going to ask whether their case is subject to judicial review, so you're going to need to know what judicial review means and what famous court case established that principle, and how state laws are affected by it. Alright, next we're going to have due process of law. We talked about it a little bit when we were covering the 5th and the 14th Amendment, but we're going to cover it more, or a little bit more now. So the 5th Amendment says that no person shall be deprived of life, liberty, or property without due process of law, and the 14th Amendment says nor shall any state deprive any person of life, liberty, or property without due process of law. They both kind of say similar things. The 14th, coming after the Bill of Rights. All right. So, we have this idea in the United States that you're innocent until you're proven guilty. Whether a person fails to stop for a red light or gets a summons or is arrested for shoplifting, following due process is almost the same. So here's what it looks like. First, the charges against you must be explained, right? They must explain to you why you are being charged with the crime. Secondly, you must be told exactly what you did wrong in breaking the law. And you must be allowed to explain your side if you want to fight the charge. The fourth step is the government must show you proof. If they don't show you proof that you did it, if there's no evidence, they can't find you guilty. And lastly, if the court finds you guilty, they must explain why exactly they found you guilty. So throughout the entire experience, there can be no unreasonable searches or seizures of a person's home or property. They need a warrant or permission to take or view things. All right, and I would like you now to write in what amendment that belongs to, right? So look in the 5th or 14th Amendment, you can Google them, and see which amendment that belongs to. Second question, people cannot be forced to be witnesses against themselves, nor can they be tried for the same crime twice. And lastly, an accused deserves a speedy and public trial with an impartial jury. They must also have a lawyer to represent them if they cannot afford it. So you're going to need to be able to ask your clients questions to make sure they're afforded these protections of due process. On your worksheet, jot down some notes on what steps should have been taken to make sure rights were not violated. You need to be able to explain what due process is and where in the Constitution provides for due process of law. Remember, even if someone's in Virginia, the United States Constitution still applies to them. All right, go ahead, um, complete your interview. You should have enough information at this time. At the front of the room, I believe, you will find the interview notes and things required for it, so be sure you do your best then. All right, hope you enjoyed. Let me know if you have any questions. Have a good day.